Tuli Machindi Koti Marshal omusango gwa Dr. Kanokiza Besigye ekiri eno tugende tubirabe bulabi Martha Kaluwa.
One of the housekeeping issues is regarding our right of access to the court as advocates representing the suspects in the law. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. Because of what transpired here last time we were here on the 10th, when Aaron Chisa was denied access and it resulted in him being jailed, we are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. So we are seeking assurances that we'll be able to represent our clients without intimidation. And today I must state that we had ease of access unlike other days, because we also want to be upfront. Today we have even been facilitated to sit together where we can be able to pass notes to one another. We thought we should bring that. The other issue is of officers who are manning the court not having their name tags. So we are not able to know who is interacting with us, and it is necessary because it's procedural that any officer who is officiating at the court should be disclosed. An issue that is may not appear very relevant, but it is. We have noticed the changing composition of the court. That sometimes one or two members are replaced, and we are requesting when that occurs, kindly let us know who has been replaced and the names and the rank of the person representing. You remember that at the start of the court, the names and ranks of all members of the court were read out. But at that time, these two gentlemen were not represented. So when they change, it throws us off balance. We are not able to know the composition of the court, which is a requirement. We have other housekeeping issues, which I'll leave my colleagues to add to. And maybe before he rises, to my colleague, professional colleague, the judge advocate, just to tell him that yes, I'm from Kenya, but I'm an East African and have an East African passport. So the unkind reference of me as a foreigner is not last time. It's not applicable. I'm an East African holding an East African passport. So apart from being licensed to practice law here, I come as of right being an East African. There is one other issue that I was required to mention before I hand over to the Lord Mayor. It's just about the terminologies. The last time the judge advocate actually said that I could also be subjected to contempt proceedings for referring to this court as a tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my team has come with a photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific matter. You are not dealing with general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are set up for a particular purpose. That's what tribunal means. And therefore, I would plead with the judge advocate, please let us give the proper terminology, proper interpretation, because they are bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English dictionary and say...
Maybe for me, if I may interject, the word court is defined in the UPDF Act. We are not going to adapt the dictionary definitions. Use the UPDF Act to define what is the meaning of court. And that is the one we shall go with.
That exactly is our problem.
Which was enacted by the parliament.
It is true.
So outside that, unless you go back, and starting from there.
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and the meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal court, which is an English language word, must be defined. And I say Article Rule 60 places a responsibility on the chairman to ensure that this court functions like other courts of law. We actually quote those dictionaries every day. In the courts in Uganda, in the courts in Kenya, in courts anywhere in the world. And I invite you to check the word tribunal so that you do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman, I just wanted to substantiate these issues with prayers. Number one, Mr. Chairman, the issues raised by Senior Counsel are quite fundamental in the administration of justice before you, or by this court-martial. From the list read by my friend here, Counsel Kampala, the name Aaron Chisa remains on the list as one of the advocates representing their chosen persons. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the team, despite what transpired the last time we appeared here, the proceedings of this honorable court. So, Mr. Chairman, We are wondering whether there will be orders every time the proceedings come. You have discretionary powers to be produced here to execute the duties, and then maybe his return. But we need you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches on the right to legal preservation, which is an integral part or a key ingredient of the right of fair hearing enshrined in Article 28 of the Constitution. And as we indicated earlier, there's a specific role he had been assigned in representing the accused persons. So we beg to be guided, Mr. Chairman, in how Aaron Chiza is going to continue featuring in these proceedings as well of counsel. And we ask that you pronounce yourself on this particular matter. Two, again, we ask, Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1, the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings of day 1, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So, the panel that was announced on day 1 is the panel that ought to have continued. Even on the day Aaron Chiza was tried, summarily and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also fundamental in line with Regulation 26 of the regulations of this court martial. Now, on the question of intimidation of lawyers, it's a very serious one. We beg that you critically reflect on this. We are concerned that the war environment is not conducive for dispensation of justice. As she has noted, and we are on record, you can see our numbers are shrinking. They are shrinking because of the intimidation which is there. There are orders that were made earlier by you, Mr. Chairman, that all the officers manning the processes right from the point of entry should be clearly identified. They should have name tags. But we continue to have officers who are moved, whose face you cannot even recognize, who have no name tags. So we don't know who we are dealing with, Mr. Chairman. And this is a known practice. I can see, Mr. Chairman, members who are part of this tribunal, Mr. Chairman. Their names were announced to us. And it's not without a reason that that provision was enshrined in the rules governing the proceedings before you. Why should we continue to have officers all over manning the courtroom here, manning the premises, handling all these the protocols here we go through? You cannot easily identify. And they create the environment to be very, very inimical to dispensation of justice, and very hostile, Mr. Chairman. And this is a key tenet of the due process, and it's a key tenet of the right to fair hearing, which is the bedrock of our criminal justice system in this country. I request that, Mr. Chairman, you make the environment conducive for administration of justice. It's a well-known principle, Mr. Chairman, that justice must not only be done, but should also be seen to be done. So it should be manifested in the proceedings, in the way all the processes are conducted, and in the way we are treated. But, Mr. Chairman, the perception, and the reality is no conducive environment. And finally, Mr. Chairman, on the nomenclature here, which is turning out to be controversial, the issue of the tribunal. I thought there wouldn't be fuss about it, because we use these terms interchangeably, even in the courts of judicature. Mr. Chairman, it has happened even in the Supreme Court to refer to the Supreme Court as a tribunal, to refer to a Chief Justice as an arbiter. And the Chief Justice does not take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter, the Chief Justice does not take offense. The ordinary courts of law do not take offense being referred to them as. Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue anyway, that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have heard some of the officers here address you as your lordship. They're saying, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court? That we're not addressing you as my lord? That we're addressing you as a chairman? I think the judge advocate and the entire panel shouldn't take offense about this. We can interchangeably refer to you as a court, we can interchangeably refer you as court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. And that is a different matter. So if I said this general court martial is not a court of judicature, I am stating facts within the law, under the Judicature Act, under the Constitution. That is not a court of judicature. And that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, because they are fundamental on the dispensation, in regards to the dispensation of justice. I beg to move, Mr. Chairman.
My name is Samuel Mwezi. Mr. Chairman, I raise on two issues. First, whereas this side we had a better conducive environment this morning, the same was extended outside. Some of us have to walk a kilometer to court. Right from the T-junction, you are faced with the blockades. I don't know why council cannot be given access to park within the premises of the court. I believe this is one of those issues that have to be taken seriously. How do I carry a box full of books from the T-junction or in the fields where we have been pushed to park? I think this should be addressed. We've seen a large parking space up here, even the premises here. So that should be handled, Mr. Chairman. Secondly, are we duly constituted as a court in the absence of reserved members of the court martial? We need to be guided on this issue too. I'm obliged. Mr. Chairman, short one, Frederick Mupata. Regarding what my colleagues have said, these are being using the words interchangeably, the terminology. Mr. Chairman, in our Constitution, Article 151, which is at page 130, touches on courts established in Uganda by the Constitution and the laws. It makes an interpretation of judicial officer. I just want to juxtapose it with the word of the term tribunal. It says in this chapter, unless the context otherwise requires, judicial officer means, under paragraph A, a judge, any person who presides over a court or a tribunal, howsoever described. It is just to lend emphasis that the application of the word tribunal or forum is not necessarily undermined court. It is just a matter of expression. Kindly request that that is borne in mind based on the spirit of the Constitution, so that it is not taken to be demeaning the members of the section. Thank you very much.
Let me summarize this. I'll start from the bottom. Council Mulima.
Yes.
This is what Council Mulima said. By the time I came, I did not even see anybody on the road. So I can't tell unless I first consult people who are managing the security. But on that one, I can't tell much about that because by the time I passed there was nothing. But if I'm not mistaken, I may add this with intimidation. The council we talked about. Much as you want to blame us in almost all issues, I think somehow some of you need to blame yourselves. Council, you have been talking everywhere what you are intending to do. And I think it cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this court. We don't know. So, security also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, I can't tell. But I believe it could have managed maybe from those statements sometimes you make. And on Council Aaron, I don't know really what you are pushing, because I've never had, unless JK will guide us also on that one, a person who is serving a sentence to come and attend the court. That one I don't know. Can get can be advised on that. Senior counsel, I don't know, you said, I don't know where this one came from. We know, of course, you are from Kenya, and Kenya is part of East African community. So I don't know that one, where it came from. But I think even a villager, once you say I'm from Kenya or Tanzania, they know. It's good you have talked about the conduct today, and you remember it was raised the other time, and you said I want to talk to these people. And that's what we want. We are not here just to, it's not a war. And I don't know why you are looking at one side, you are not looking at another side. People making noise in the court. To the extent of even of standing on the chairs which are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you want to, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere. Once a council or anybody submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. I don't see where can friction come from if we are following what we are supposed to. Unless, if you have, especially the council who was asking about my vote versus chairman, I think the reserve members. Sir, I will take the opportunity to respond to the legal issues arising from the submissions of defense lawyers. And I will also refer them to carefully Regulation 63, which talks about the duties of the judge advocate. Sub-Regulation 1 says that the prosecutor and the accused respectively are at all times, after the judge advocate is named to act at the trial, entitled to his opinion on any question of law or procedure relative to the charge or trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, holding this court a tribunal, that one will not happen. The UPDF Act defines court-martial as a field court-martial, general court-martial, or court-martial appeal court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintendent over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adopt dictionary definitions. Secondly, the issue of Aaron Chiza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause 3. Sometimes I never to read because when I refer to read, they say I should read. So I will read. It says every person who is right, that's the right to a fair hearing. Every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Elon Chiza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be wrong here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because the person who was convicted before this court is not there, and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no. And if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Chiza has a specific role, to me that doesn't make sense. I think I'm done with that. About the environment not being conducive, the person raising this matter is ably submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Council Kwago, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in reserve, were present, and all the members before you have been following this case, have been in court. So the fact that you are seeing one is not there, whoever is there has been here or from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notice. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Bang, I will not point to it because I have already given my position. But Senior Council Karua said that me, as a brigadier to Kachungu, I called you that you are foreigner. I have to ask you, if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you called you a foreigner. We have interacted, but it has never come out of my mouth. That is my responsibility.
May I, Mr. Chairman, remind my learned friend here that it is actually on video. You refer to me as a foreigner.
You bring it. You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
My question is, the court members, we are going to proceed. This case was...
Which court has not pronounced itself? Which one? There's no prior to legally the proceedings where the pan has been shifted. That's what he was explaining about. That's what he was advising the court. It's not that, it's not, he was advising who to take a decision.
Council can read the also if it's an issue that we have changed. Can he say also
it's like this council of members of this court.
I can even reply, I think I didn't address that one. But if court pronounced itself on the matter, if you feel that you have proof that the court was not fully constituted, you have an avenue of appealing and challenging the decision of that court. But you cannot raise it here that court is going to pronounce itself. Court was properly constituted, it took a decision. Now, for you who is aggrieved and saying no, then we have a commercial appeal court. Appeal with proof. They will give you an answer.
Would you therefore kindly give us a list of those who sat at the sentencing session for Aaron Chisa, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at, we have looked at the Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Chisa when he is in court as an advocate. And the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like referred and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought we are responding to
You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what the senior colleague is referring to, Madam Chairman, I think she will need to address herself on the procedure, especially on references under our rules, Constitutional Court petition reference rules. And I don't think by submitting that she's seeking a reference from this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, Madam Chairman, I pray that we proceed with what the merits of today are, instead of going against what the rules of reference provide.
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you open again the question of jurisdiction was the first thing we dealt with when, before I took even a plea, and the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg you to proceed to the chair. Maybe Council Kwako was saying, calling you my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even it's the question worth asking him that he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues come, again, just for consistency, we kindly request.
Council, let's not repeat what have been said and answered.
I'm not going to repeat, Mr. Chairman.
Yes.
I'm only asking that because we are many, if we can kindly follow a process whereby if a matter is raised with the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding so that the matter either rests or is left pending. And why we are saying so, Mr. Chairman, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge advocate. Why am I raising this? Otherwise, my lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it will appear then that the judge advocate is either coming into the realm of the state and also taking over the realm of the court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to a conclusion. It would be unfair to Mr. Kalibala, for example, if he laid his evidence before me and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Rwa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chairman, that the issue of the panel is completed. My neighbors whispered, and I am sorry if they are wrong, that at the last sitting, your neighbor to my right exactly was not on the panel. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the panel. Other members before have said that there was one lady, now there are two. I think that causes a concern and may go back. So it raises an issue that if we break the consistency of the panel which constitutes the court, then the judge has advised that they are following the
may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for the accused persons, that they themselves, no matter the decision of the court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, I think it's good that they are here. So that, and I think that's a simple matter. If they say the reserved members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them. I think that will be so much. So I request, Mr. Chair, before, and maybe we first state the issue of the reference, that we put finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for a time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision hears us out. It's our polite request, Mr. Chairman.
Mr. Chairman, on the same, my whisper was not quoted by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was our observation. I think it's to be clarified. Secondly, I think my issue of parking includes access, my access as council, access in court. I'll be on record. I'll not come back to this court if I'm parking 1 kilometer away. Access includes me parking within the premises. I think that needs to be also clarified by this court. We need a conducive environment as council with accused persons. I'll not carry a box of books like I did today, 1 kilometer away from here, Mr. Chair.
Sorry, my neighbor is killing me. He says I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They alleged it is a name of Kaleko, and the collar was red. So we don't know whether the person there has lost the red part. But my daughter, as you can see, but it's a concern that the people here in us out, when they are changing, there is a concern that may not be had fair and square. It's our polite request, that the court makes a pronouncement before we go further regarding the consistency of the tribunal. Of the panel constituting the court. I'm sorry. Of the panel constituting this honorable court.
It's all right, Council. Yes, the other day there was a Kano here, as you have said, Kano Kaleko. But as you heard from Judge Advocate, we are 19 members. 7 are supposed to be here, including me, and then the reserve is supposed to be behind there, so that's 7. But maybe some have misplaced by you. But you. They are few. Yeah, I can see. It's that when in the case one maybe have a problem of fees, he can go out and another one come in. That's how we usually operate. Unless we add on something, but that's how we operate. Then the accessing the court. Council, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And
I think so what I can inform the lawyers is that this part of the court is consistent of composed of 7 members before it can conduct business on any case of capitulation. We have 7. There is now no case arising before this court where Major Sara was not present. So we are ready for today's session, sir.
Mr. Chairman, we need to put this in context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually it does not stop there. It requires that if there are objections to any of the members, the accused persons are at liberty to say so. So if the panel keeps standing like we have told Captain Okarebo, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. That have not had the pronouncement of the court martial, the validity of the proceedings, because it was not done at that on the day. Actually, Lero Akigudeko was summarily tried and convicted when Captain Okarebo came in. Kano Okarebo came in. When Kano Okarebo came in, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings which were conducted in outright violation of the regulation that requires that you make a declaration that this is the tribunal that is going to try you. So this is the whole point we are making, Mr. Chairman. So if, Mr. Chairman, we continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself, which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need, like, in reinforcing the submission of my land friend, let the court make a pronouncement, a decision.
Council, the culture here is, once an chosen person is brought in the docker for the first time, he is introduced to all members here and the members, which was done on that day. So this, our changing of position or alteration, just is when we are proceeding. Or maybe, unless you are asking that, where is your Okarebo now? That's what you are asking.
Not only that, the validity of the proceedings, the legality of the proceedings, where a member of the panel is not introduced because Captain Kano Okarebo was never introduced. That is the person. This is the point. All the accused persons, these ones in the dock and the Lero Akigudeko, because he was also put in the dock here briefly. So Okarebo was never introduced to the accused persons.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or persons appear in the dock. And they are asked, they answered, they had no objection.
And make this up for Chiza, let me educate to counsel power. On contempt of court, you cannot say that Chiza was supposed to take a plea, he was supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how it is, the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
But I think you need to close the chapter of Chiza because he was convicted and sentenced. If you are not satisfied, you know what to do. On that one, I think let us proceed.
He's still on the part of the lawyers.
So should we adjourn up to his finishes his sentence?
The guidance we are seeking from Mr. Chairman. How do we deal with this?
About
the instructions.
About the convict. The one who is sentenced, who is serving the sentence.
But he still has instructions, Mr.
So which
Chairman.
means all of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are restricted to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron Pastor happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think, sir, we need to move forward.
Mr. Chairman.
And we close the chapter. All matters have been...
No, there we are closing the chapter, but what I want to tell the defense attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. Chairman. On the issue, yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, well, when the ruling which resulted in sentencing my land friend Aaron Kiza was being read, reference was made to his earlier conduct in 2024. But Colonel Okalebo was not present in 2024. However, he participated in sentencing Aaron Kiza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
So I think you need to give them the list, the other instrument of ours, so that they understand the position of this court.
Whoever wants, we have our one just right there. And they are also advocates. They are there, they are sitting. Don't just think they are clerks. The major and the one next, they are also advocates. They manage our registry, which is also under my office. So you can ask anything. If it is an instrument of appointment, they have it.
Go ahead, go with this state.
Mr. Chairman, just the last one, the very last one. It touches me personally. Mr. Chairman, it touches me. Mr. Chairman, I beg, Mr. Chairman, your indulgence, Mr. Chairman. I thank you. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman, I beg for your indulgence.
Lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
He has not
It's a rumble, I know, and
this is what we are saying now. Because if you are to conduct ourselves like that, then we may not go anywhere.
because, Mr. Chairman, we are dealing with matters of life and
Since we started, we are talking. Let's see.
Mr. Chairman, it all depends on the gravity of the matters we are dealing with. The sentence we are talking about here is there.
Chairman,
The charges is there.
I suggest you rail on also for a vote. You should respect the chair and vote. Two lawyers cannot speak at the same
Councillor Fire proceed.
On the 7th of January, when this matter came before the court, I included this talk that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed to challenge the court.
kale byebyo ebiri mu Koti Martial musango gwa Gamukanuse Besigye bigambo abalamuzi abalo tebategerekeka obuyigirize bwabwe ebifo bye balina amayinja gaabwe babagwanidde buli kadde babakyusakyusa abalamuzi n'amateeka Besigye kyebagamba nti tekikwatagana na biragiro n'ebirina okugobererwa mu kooti. Wanzo okubawo ekitambula naye nga kifu n'olwekyo baagala bisooke bitereezebwe balabe nga bagenda mu maaso. Kale bibyo ebiri ewa Besigye tunatambula bino n'abava tuno batu byategeeza Mukama bakuume mwera.